Thank you. Thank you, Venu sir, and thank you for this group for giving me this opportunity to share some of my thoughts on practical aspects of writs, which is a constitutional remedy available to the citizens of the country, especially against the government. My main focus or epicenter of this presentation will be to talk about writ remedies with respect to GST litigation or GST matters. But directly going into GST may not be uh, may not be right, may not be appropriate. So I would like to spend a little bit of time, not much of a time, but a little bit of time on the basic aspects, background, introduction of writs, and this is the index of the coverage I am going to cover today. Introduction, the meaning of the writs, what is the background history behind writs coming into play. Then what are the relevant articles of the Constitution which give this remedy? And there are specific five types of writs. Specific writs are there apart from generic orders or directions which the high courts or supreme courts can issue. When it comes to GST, we can go for writ remedies at various stages. It can be at the stage of show cause notice or pre-show cause notice, or at the after the issuance of order in original, or after the first appellate commissioner issues the order, or against the GSTAT, which is yet to be operational. After this, what are the issues involved in each of the at each of these stages? I will try to cover them. And next, nature of controversies in GST, which have already reached High Court. The kind of I will just take example of few of the important major controversies which have reached High Court, or some matters have reached Supreme Court also after High Court. And basic to do activities, or basic some kind of a pre-checked precautions, housekeeping we need to ensure before going for these writ remedies, because these are not uh, these are not uh, these remedies are not without any restrictions. There are restrictions and conditions subject to which you need to avail these remedies. So ending with Q&A, maybe 10 or 15 minutes, last 10-15 minutes of this next 1 hour. So going to the introduction, this India is a welfare state where government is responsible to ensure the welfare and you know uh, taking care of citizens of the country. And to ensure that uh, the power of the government, uh, which the government can exercise on the citizens of the country, need to be checked. And this is kind of a Article 32 and 226 of the Constitution are nothing but an exercise of control over the executive power of the government. And these articles 226 and 32 give wide and very wide and extraordinary powers to the uh, High Court under 226, Supreme Court under 32, to exercise the power, this extraordinary power, to make sure or to ensure, to enforce the fundamental rights which are uh, part of Part 3 of the Constitution. There are various fundamental rights. Whenever there is a case of infringement of any of these fundamental rights, the citizen can move the High Court or Supreme Court. Uh, these uh, these are called uh, these high courts or Supreme Court are generally referred as courts of writ jurisdiction, or they are also with an exercise to give prerogative remedies. These are also called as writ remedies. Before going to High Court, there is, as I said already, there is no direct uh, you know uh, 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 approach that should be made to approach this High Court or Supreme Court without exhausting the alternative remedies which might be available under the statute or under the law under which you contemplate that your rights, your legal rights are infringed. If there are legal rights which are infringed, you need to first exhaust the alternate remedies which are available within the statute. As the statute gives certain rights, it also gives remedies. Without exhausting those remedies, subject of course to certain exceptions like fundamental infringement of fundamental rights or violation of principle of natural justice. There are jurisdictional infringements in certain exceptional situations which have arisen out of various Supreme Court rulings. Only in those cases you can go ahead and file the writ petitions before the High Court or Supreme Court, as the case may be. So this is a little bit of introduction about the writ. Writ is a is a tool available with the citizens of the country to bring forth any rights, legal rights or fundamental rights which are infringed by the government, or in certain cases by any other person other than government as well. The meaning of writ technically it is nothing but an order which is issued by the Supreme Court or the High Court, which is called a command on the executive body of the government for violation of the fundamental right or any other legal rights which are conferred on the citizens of the country under any statutes. And it is generally issued against the government agency officials or another court, apart from certain private parties also. So it is writs are not high courts or Supreme Courts are not the fact finding authorities. They are not the fact finding authorities unless there is any uh, unless the facts are not under dispute, or they are not seriously traversed as per the affidavit. In High Court and Supreme Court, all the submissions are done only on the affidavit. There's no evidence. There are no evidences in relation to facts which is mandatorily required to be submitted to the High Courts or Supreme Courts. It only goes on the affidavits or solemn oath of the person who is making these submissions. It goes only on on those bases. Background: prior to independence, there were only three high courts in the country: Bombay, Madras, and Kolkata. And that too, the power of writ was restricted to only the jurisdictional, original jurisdiction of those high courts in those local, I mean, geographical jurisdiction of those high courts, and it was not available to everyone across the country. So, uh, to expand it further, to provide this remedy to everyone in the country, Article 32 and 226 was inserted in the Constitution, and this power was widened. This power was given to every High Court in the country, and also Supreme Court, to confer jurisdiction uh, by high courts in those respective states and Supreme Court across the country. Whenever there is a case which is brought forward where there is a fundamental right violation, or any other legal rights of the people uh, are under question or under violation. Article 32 gives powers to Supreme Court to issue directions, orders, or writs, apart from a specific five writs, which are habeas corpus, mandamus, prohibition, quo warranto, and certiorari. So these are all five, specific writs. Uh, I will just take you through what are the meanings of each of these writs. Apart from these, there is no restriction on the powers of these High Court and Supreme Court. Is under Article 32 to the Supreme Court to issue any other direction or orders or writs, because as I said, this is a discretionary extraordinary power, the Supreme Court, where it can issue any direction as it likes, depending on the situation, and orders any other orders or any other writs apart from these five, in order to ensure, yeah, for the enforcement of the rights conferred by this part. When I say by this part, it is part 3 of the Constitution, which gives fundamental rights to the citizens of the country. Whenever there is a case of violation of fundamental rights, infringement of fundamental rights, Supreme Court, uh, the citizenry can approach the Supreme Court and plead before Supreme Court and get the relief. So violation to approach Supreme Court, every issue, even if there is any legal legal any other statute like GST or any other fiscal tax matter, there is a violation, there is a uh, you know uh, uh, some hindrance or problem which citizenry is facing. Supreme Court, he cannot approach Supreme Court unless there is a strong case to say that there is a violation of fundamental right with respect to Article 14 or Article 19 or Article 21, and likewise there are other articles 15, 16. Any case which has got which case of violation of fundamental rights is a sine qua non. It's a mandatory prerequisite before somebody goes to High Court, Supreme Court. Coming to Article 226, which we most of us in GST or any tax matter we approach or respect to jurisdictional high courts whenever there is any order or any show cause notice is issued under these laws, and yeah, there is a case of violation of fundamental right, or most of the time principle of natural justice violation is the case we make out before these high courts. Article 226, if I read it, notwithstanding anything in Article 32, every high court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person. The word any person can be underscored, or authority, including any inappropriate cases in any government within those territories, directions or orders within those territories, directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, etc., for the enforcement of the rights conferred by Part 3 and for any other purpose. So here the uh, uh, express difference which you can find under Article 32 and 226 is, under 226 you can file a writ against not only government authorities, or any government company which has which is called a extended arm of the government. You can also file writs against any person other than government also. There are cases, there is a jurisprudence around this which says that any person who is having public function or public public obligation, public obligation, even those persons can be writted under Article 226. And not only the fundamental rights as contemplated in Article 32, 226 can be invoked even for violation of any of the legal rights which are conferred on the citizenry under any other statute like GST. Even the legal right violations can be brought forward and uh, and made a case under Article 226. So if I go to specific writs, habeas corpus is an exception to rule which generally understood that writs are only against the government authorities. Habeas corpus is the only one which can be issued to any person including a private person also. There's without any ambiguity. When if somebody who holding the custody of his person, that person can be brought, can be through this habeas corpus writ, he can be asked to bring that person who is under his custody to for to justify his detention, and failing which that person, if he cannot justify his detention, it can be a jailer, it can be a policeman, or any other private person also. It is with respect to, it is directly in context, in the context of Article 21, which talks about uh, freedom of life and liberty. So this is strictly against physical, physically you're holding the custody of somebody unauthorizedly, or without without authority of law. You can be asked by this court, Supreme Court or High Court, to bring that person to the court and get the justifies detention. Mandamus is the one, the most of the GST thing, we or income tax, we seek High Court's intervention to issue mandamus. Mandamus is nothing but a direction or an order to be issued to the government or public authorities to do certain things they are not doing, which they are supposed to do under the law. If there is a delay in adjudication of a refund application, or there is a rejection of certain plea or certain request made to the commissioner of income tax or GST, if that is not taken cognizance of, or not not addressed, those matters can be brought to the High Court and mandamus direction. An order can be asked to expedite, or push the things forward. It is a positive direction. It's nothing like, don't do anything. Don't do anything is another writ petition, another type of writ, which is prohibition. Prohibition is exactly, kind of a opposite of mandamus, where if certain some officer, some tribunal or government authority is doing exceeding his powers, jurisdictional powers, he can be asked to abstain from exercising that jurisdiction, which they do not possess, or they are going beyond what they are authorized to do. So it is only to hold them under control if they are exceeding their powers. Certiorari is also very generally used in GST tax matters, where any order is issued, especially order in original issued by the adjudicating officer, which or maybe appellate commissioner, who confirms this order. We can request the High Court to issue a certiorari, get that order onto on the record of the High Court, and to adjudicate it, and quash it if it's a fit case to be quashed after adjudication. When subordinate or quasi-judicial judicial authorities like GST department acts without or in excess of jurisdiction, in contravention of the rules of natural justice, or commits an error apparent on the face of the record, High Court is empowered to issue these writs. These are only instances or examples, because writ is something very extraordinary power with the High Court. It's a discretionary power, and these whatever instances, examples we are quoting is only based on the previous precedents or previous decisions or judgments of the High Courts and Supreme Courts. But these can go, the instances can be beyond these also. The main objective or intention of certiorari is to keep all the subordinate courts and quasi-judicial authorities or tribunals under the limits of their jurisdiction. If they are trying to exceed their jurisdiction, or powers which are conferred under their respective statutes, they can be brought under control by issuing certiorari. So certiorari we are using in GST most of the time. In GST we are using it to quash the orders which are issued by appellate authority or the adjudicating officer or GSTAT, which is going to come in future. Quo warranto is nothing but questioning the public officer who is holding the position about his legitimacy or validity of him holding that public office. It is mostly in labor matters. This quo warranto is used to question the public officer's position which he is holding, whether it is in accordance with the law or not, or is it legitimate under the law or not. These questions are uh, asked, just like habeas corpus. This is a questioning on the validity of the position which any public officer who is holding. Much of not much of a relevance in the GST context. So sorry. So there was some attempt made by governments in the past, 1976, by Congress government, then led by Mrs. Indira Gandhi, uh, which actually was an attempt to whittling down or reduce the impact or powers of high courts to hear the matters or to hear the matters or cases where there is already a statutory remedy which is available straight away. If there is any statutory remedies available in the statute, irrespective of the fact whether fundamental rights, violation of principle of natural justice, etc. Even if they are violated, no questions to be asked to or no case can be made out in the High Court or High Court. This was the intention of this amendment of 42nd Constitutional Amendment Act of 1976, which inserted Article 226(3), which had an impact of whittling down or reducing the impact powers of High Court at that time. Then subsequently followed by emergency was declared, and post emergency Janata government came up and uh, undone whatever Congress has done and deleted that Article 226(3), which had an impact, major impact on the citizens who cannot go to the High Court if there is a statutory remedy available, even if it is not effective, even if it is burdensome. No questions were supposed to be asked, and High Court was not a remedy available that time. So there was also a talk parallelly going on around that time by Revenue Department, Income Tax departments per se, regarding people approaching these courts, high courts, just based on the frivolous allegations, just to postpone things, not to pay taxes, to avoid tax, to delay tax, by getting stay. So this was the plank on which the arguments was made by Congress. Apart from Congress's, the government's own intention to keep the judiciary under control, there was a agenda to keep the to keep them under control. So this 42nd amendment came up, but this was reversed by government in 78 through a constitutional amendment. Sir, you have a question?
Yes, sir. Yeah.
Yes,
So now between this brief period of 42nd Constitution Amendment to 44 Constitution Amendment, 226(3) is in operation.
Yes.
Now, after this is deleted, the acts done under 226(3) during that period, would it be valid or can that be questioned?
I think it's a very old, may not be relevant at this time, but
no, I'm looking the answer again from the GST perspective. Like we get some amendments and backdated amendments, and like if you look at 9(4), the 13th October 2017, yes. When it was deleted. So you're still thinking that will it be operational? And there are different views and some explanations that comes, and we treat it as retrospective. So since this was on a constitution, So how
Correct.
would Constitution read this is what I just wanted to understand.
This is a kind of a clarificatory amendment, sir. Clarificatory or declaratory amendment, which is trying to, correct the some problem which is going on at present, which is trying to correct. If such kind of amendments are done, whether in constitution or statute, any other statute, they go back in time. They get retrospective effect. If any such things have happened during that short span of time, I think those will not be valid because in view of Article 226(3) has been removed from the Constitution. It retrospective effect, sir.
Okay, got it, sir.
Justice Krishna here in the same context, in the case of Rohtas Industries and Rohtas Industrial Staff Union, way back in 1976, he has used this quote, which I liked it, and it is used repeatedly by various, judgments by other high courts and Supreme Court also. The writ power has, by and large, been the people's sentinel on qui vive, and to cut back or liquidate that power may cast a peril on human rights. So it is directly, talking about the point where human rights, fundamental rights, these are all basic, basic structure for constitution. They cannot be imperiled. They cannot be put under risk by, whittling down the powers of high court, because they are the gatekeepers. They are this, kind of a border security agents, kind of a, uh, bodies, authorities who are responsible for, withholding or upholding the rights of the citizens. So this is the one important quote from one of the judgments, which I thought I will bring it out. So coming to GST context, sir. First is at the show cause notice stage. Whenever show cause notice comes up, generally general feeling is it is it is it is uh, prejudicial, or it is a one-sided, without giving consideration, or to the submissions made, which taxpayer may have made when audit was going on under 1965 or pre-show cause notice. We get a feeling that we are unduly harassed by the public, by the authorities. So at that time, anybody can get tempted to approach High Court, but without exhausting the remedies which are already available under GST law, under 107, or reply to show cause notice. All those options are there. You cannot bypass or bridge a gap and go to High Court directly. So writ is not a substitute, is what I'm trying to say. When you are when you're slapped with a show cause notice with a high demand, okay, and the whatever interpretation, whatever thought process you may get, or by seeing the writ petition, may be shocking or preposterous, absurd, invalid. Okay, they are all your own feelings. It doesn't matter. It may not be. It may not be true in the sense, in the eyes of the court or in the eyes of law. Just because you feel that you are being harassed, or you are undue tax demands are made against you in the show cause notice, is not enough. It's not enough down to approach High Court directly, because when GST law has given a right to answer to the show cause notice issue, it has given a forum to challenge these kind of notices or allegations made, charges made in the show cause notice. You need to first exhaust that and use that opportunity. Mere apprehension of justice from SCN not a sufficient ground. Just because you're apprehending that this SCN is going to get confirmed tomorrow is not a sufficient ground. Okay, you cannot go to High Court and tell that I'm apprehending that this SCN is going to get confirmed, or demand is going to get confirmed. Is not a sufficient ground enough to go to High Court. So alternate remedy is generally comes on the way. It's a kind of a threat, or it's kind of a hurdle. People who are zealous, extra zealous to go to High Court and file writ petitions. And in my own example, Jatin sir has stopped me many times to go to High Court in several matters, where I myself have changed my path and went to get the statutory remedies, and I I I found myself I did a right thing to do that, because day in and day out I see a lot of writ petitions, a lot of effort is put on the writ petition, money, cost, expenses, resources. Finally, judge says, go to statutory, appeal, whatever statutory remedy are available, go there and do it. Don't come to here. This happens very often. You need to have a very strong case if you want to go to the High Court through 226 route. So there are, having said that, you have to first approach the statutory, appellate forum, or whatever remedy available there. Then only you have to come. There are few exceptions which have been carved out of uh, common law of our India, which is come out in various judgments or Supreme Court rulings. These are some of the exceptions which I'm trying to list here. Which, if your case is falling in any of these exceptions, because these exceptions are not exhaustive, these are only illustrative. These are the examples which are generally we have seen it, people using these reasons for going to High Court. Exceptions to alternate remedy: SCN issued without jurisdiction. If the power which is exercised by the authority doesn't have jurisdiction at all, maybe it may be legal jurisdiction to demand the tax itself, or it may be a geographically is not doesn't have jurisdiction exercise, or cross central state matter, that particular officer who is issuing SCN doesn't have jurisdiction, then it can be a strong ground which judges generally consider to admitting the writ petition. SCN is used without authority under law. If there is no authority, only jurisdiction comes later. If there is no authority at all under the law to issue certain SCNs, because we have seen Section 122 has been used. A lot of people, a lot of officers in the initial days, maybe today also some parts of the country, practice is still there. They are issuing show cause notices under Section 122. There is no power under 122 to issue SCN. So those kind of cases also can be court adjudicated through the High Court intervention. SCN has predetermined the issues, like in Infosys we have seen recently in the news also. Pre-SCN is issued. In that case, there is a pre-SCN issued on 232,000 crores of tax on a predetermined certain assumption, or there is a definite assumption that there is a tax on the part of the officers who are issuing it. Even those cases which are actually prejudicial to the interest of the taxpayer and burdensome. SCN is cryptic. It is not clear. It is not following the law. It's not. Yes, sir. Very, sir.
Sir, when you are saying that they predetermine the issue, now aren't it every classification issue is like this? Isn't it not a alternate remedy and not a writ remedy? Like even in the case of the cardial on the gambling casino cases and other things. So the department had made a view. So instead of exercising alternate remedy, can I jump the gun? Or is it because of the quantum the writ would be allowed?
Quantum is never comes into on the way, sir. Quantum is there, even if it is for 1,000 demand, they will do the equal weightage. Here, sir, predetermined, I mean to say, before SCN, I must have gone through different stages before also. If none of my submissions were accepted, And 65 is classical. 65 audit. I have given my submissions. I've published everything, but there is a predetermined mind to confirm the order. There is no whatever replies I am giving. Those replies are not considered. They are just thrown out. And in those kind of cases, it's a strong case to say that they have decided they are going to confirm the order through this SCN.
So will
Yes, sir.
yeah.
So it is based on the wordings in the show cause notice. Ganesh sir, if I am wrong, please correct me. It is based on the wording in the show cause notice. If you see state departments, they normally say audit report they are given this and reply they are given this conclusions. That means they already concluded the case. See, because the adjudication process start with show cause notice and then it should be concluded. But many of the show cause notices, they are missing the golden word appears to be. See, any center show cause notices, if you see, they use the word appears to be and they will not say you are liable to pay. See, once they determine the word tax by saying in the show cause notice itself, they say that you are liable to pay in so amount. So that is not the show cause notice, it is determination. They already determined. But show cause notice should be, it appears to be so and so amount is liable. Why it should not be demanded? You show cause. So this is the procedure because the wording in the show cause notice which help us to file a writ and to say that the department has already predetermined, they already decided the case,
Understood.
and the show cause notice is an empty formality.
Correct. So words of the show cause notice are clearly reflective of the fact that they have decided, explicitly they have decided that this is a confirmed liability on the part of the taxpayer. So I was trying to bring out a case where none of my submissions were taken care. They were not considered at all. They are just on a single liner. They have said we disregard your submissions. So even there also there is a indirect or hidden meaning that there is a determination in their mind to go for confirmation of the order. SCN.
There it can be a speaking order, so non-submission, not a speaking order, but it will not be much.
SCN is cryptic. Cryptic is generally I have seen a lot of people saying that SCN or order is cryptic. So whether it is SCN or order, it should be a speaking order. It should be in terms of the pro forma formats which are issued by CBIC, and it should contain all the relevant information, details. If something is not clear for which can enable the taxpayer to respond back to the SCN, which is a case of cryptic SCN, which is doesn't has what hidden agenda, doesn't have clear expectations from the taxpayer. Tax officer himself is not clear what are the charges or what are the allegations under which section he is making those allegations or charges. So in those kind of cases, also those SCNs are quashed at the threshold. SCN barred by limitation. There is no limitation act applicability in High Court. This is important information. Limitation Act is not applicable for High Court or Supreme Courts. Okay, they use the Limitation Act only as a measure of measure to check there is no undue delay latches on the part of the taxpayer, on the part of the aggrieved person to approach the High Court. But even if there are cases where aggrieved person goes beyond the limitation time prescribed in the Limitation Act, because it's extraordinary jurisdiction, depending on the facts, specific facts and situation, High Courts have allowed those petitions to be admitted. So Limitation Act is not applicable. People generally say Limitation Act use so much time, so I should be allowed. If the time limit is not specified in the statute, so we need to go by the Limitation Act generally. But it is not a hard and fast rule that Limitation Act is applicable for approaching High Court. But being a vigilant person who is aggrieved, who says he is aggrieved, not sleep on it for forever or for a long time. Okay, he need to approach the High Court as soon as possible. As soon as possible is a very esoteric word, very difficult to define. But in the views or judgment of the court, there should not have been an undue delay on the part of the person, taxpayer, who is approaching the High Court for asking a remedy. SCN issued amounts to abuse of process of law or modified. This is overlapping with other exceptions where there is a process of law is clearly visible. There is a abuse of power by the authorities to demand the taxes. If the such case is made out clearly to convince the courts, it can be a strong ground. Raising demand for tax without authority of law. I think earlier second point, bullet point was on SCN per se. This is on the demand. He has got power to issue SCN, but there is no power to demand that such taxes from the taxpayer. So this also can be a one of the reason or ground for going for writ petition without going for statutory remedy. So these are only few of the examples where alternate remedy can be bypassed and High Court we can approach the High Court directly under 226. The last bullet, which is there in red italic, I have picked up from Jatin sir's SCN book, show cause notice book, which has really attracted me. When I approach High Court, the injustice which I am trying to make out, which I am meted out, it should jump out of my petition copy itself, is what sir is saying. I'm fully convinced with that. The injustice, the High Court judges are like they sit in the position of a god, and in their eyes, if that injustice, it should catch the injustice which the aggrieved person is seeking relief against. Injustice must jump out of the pages to demonstrate maintainability, and no other forum other than High Court is empowered to allow relief required. So my petition, my papers, my submissions, it should clearly reflect that there is some hindrance, some injustice I am confronted with. And that is the reason I'm approaching High Court directly to get a quick and expeditious relief. Next, yes, Deepak ji.
Sir, in case of these alternative remedies, what you had suggested,
Yes.
so the normal appeal route also we could raise these points. So what will make the judge at High Court to encourage a writ and not tell us that why don't you go for the regular?
If I understood your question rightly, what motivates the judge to admit the writ petition instead of alternate remedy, right?
Correct.
Sure. So these are the exception reasons I give now. If there is a violation of fundamental right, in this SCN stage, there is no fundamental right question may not arise. But if the officer doesn't have jurisdiction, he's very, it goes to the root of the issue actually. He doesn't have power only, but he's still trying to exercise the power. Then judges will not be justified or will not tell, go and approach appeal commissioner or reply to SCN, because it is void ab initio. From the beginning root itself, it is wrong. So in those cases, there is no authority under law to issue SCN or to demand tax. Cryptic notice which is not clear. These are all very gross and serious issues where even if citizen approaches the High Court, may not get relief on time, may get relief, may not get relief, or may get, I don't know. I would say he may not get relief because they are, yeah. I mean to say these kind of exceptions, these kinds of problems which are if they are faced, then definitely High Court can entertain these petitions. They are motivated to hear these matters where there is a gross problem, where there is a question on the constitutional fundamental rights or legal rights. What I said earlier, legal rights are violated. because I have right, I have a right to question the legal sanctity or validity or action of the officer who is issuing this SCN on me, SCN to me to respond back. Is it fine?
Got it. So another question, yes, sir.
Yes, sir.
Another question. The writ jurisdiction lies with the High Court as well as the Supreme Court, right?
Yes.
So is there any kind of a parameter to decide when should we go to the High Court and when should we go to the Supreme Court?
I think I covered that earlier, but let me reiterate. Supreme Court only when your fundamental rights are violated. Only when fundamental rights are violated and only against government authorities. But in 226, not only fundamental rights, any other legal rights against the government or against any other private parties also. The private parties having public responsibility, public duty in large, like universities, colleges who are funded by government, who are under the jurisdiction or supervision of the university. Even those people can be rated under 226, but not 32. 32 only, the basic Article 14, 21, 19, all these articles, if they are under question, they are violated. Those grounds can be taken and approached Supreme Court. It is
Sir,
not
is there
mandatory that you have to go through High Court only.
Is there any corresponding provision or article in the Constitution which tell us that these cases we need to go to High Court and these cases we need to go to Supreme Court?
No, no. This is the common law of Indian judiciary. This has come out of case laws, judgments of the courts. There's no hard-bound rules on this. So Article 141, according to that, there is a consistency. Everyone need to follow whatever higher court says. It's been followed even now. Even if today, if I file a writ petition on these grounds, these exceptions which are listed there, they're subjected to scrutiny by the High Court, and only if they're satisfied that these exceptions are there, which are already accepted or admitted by Supreme Court or High Court in the past. And there is jurisprudence, there is a acceptability of these exceptions. There's no rule, there's no hard and fast any article or section which provides for this.
Ganesh sir.
Yes, Sujata madam.
Yeah.
Yes.
Ganesh sir, this one, whatever you are saying as exception to alternate remedy, is it because the tribunal has not been formed, or how is that? Because, for example, show cause notice issued without jurisdiction. See, these cases, when there is a lack of jurisdiction, then it becomes a void ab initio. So you have a remedy available at the first stage, again at the tribunal. Without exhausting these options, when you directly go to writ, calling it as an exception, will they not throw you out saying, no, this you go to that alternate remedy, then you come back to me? So what is that? What exactly is that meaning of without jurisdiction? Under which cases? Can you give some example?
If you are issued a SCN by a GST officer who is not your jurisdictional officer, madam.
Okay.
Somebody else from Maharashtra state, if you are doing business there, if somebody sends you a show cause notice to you in Bangalore, then he doesn't have jurisdiction over you. He cannot issue. It's a void ab initio, and you don't need to go to appellate forum under the GST law. It is a accepted principle, and they will accept, admit, and question the jurisdiction of the officer on the other side and ask him to justify how have you done it. And question is admission of this petition. This petition will get admitted if there are jurisdictional grounds which are raised. Without thinking, they have to admit and they have to adjudicate and they have to see whether the question raised is valid or not. If it is valid, they will hear it on the merits and decide the matter.
No, see, when some other, see, for Karnataka, so I'm getting a show cause notice from Maharashtra, assume. The minute I reply to Maharashtra, that there itself it ends, no?
No, but he may sit on his
He will
demand. He may
proceed.
again confirm the order. You can do that always. That option is always available with you. You can reply to him and you can file appeal. But you have this remedy which is readily available. If you want, you can go to High Court also approach. There's no problem. High Court may not dismiss your petition. Is what my point is.
Thank you.
Yes,
Ganesh sir. Yeah. Can you give few instances or examples where, I mean, in the context of GST law, when a taxpayer or assessee can approach Supreme Court instead of High Court?
So far, I have not not experienced any such case where directly people have approached Supreme Court. I think, yeah, I don't think if you have a strong case where your Article 19(1)(g), for example, your right to carry on with the business is impaired. If you have a strong case, then Article 32 you can invoke and go to Supreme Court. Right now, whoever has approached Supreme Court, they have gone through this High Court route only. After they have failed in High Court, they have filed SLP and got their SLPs admitted or dismissed, whatever, at the Supreme Court level.
Okay.
If for IGST matters also, I can go directly to Supreme Court, no? Say, for example, some place of supply, there is a dispute. So instead of going to High Court of Karnataka, can't I go to Supreme Court?
IGST case is a statutory provision, madam. It's not a.
Yeah, I don't get remedy in my at first appellate level. So
Then you have your jurisdictional High Court. Are you whether your fundamental rights, any of your fundamental rights are infringed or violated?
Something like that, relating to place of supply. There is a violation of my fundamental rights. There is an impeachment. So can I approach the Supreme Court directly?
Yes.
I'm just giving my thoughts.
Yes.
Well, maybe I may be wrong.
Yes. See, the broad line is if your fundamental rights are affected, infringed, Supreme Court can be approached. Okay.
Now, when can I bypass High Court and go to Supreme Court is the question. Just a continuation of Kuber's question.
Yes, that is the answer I'm trying to give you, madam. It's your fundamental rights. Article 14 says equality of law, equality principle. If your equality doctrine of Article 14 is violated by the GST authorities, then, in my humble view, you can approach a Supreme Court. But you have remedy under High Court also. You can approach Supreme Court, of course, but you have remedy under Article 226 also. If you can approach High Court, the obvious question, natural question is why to go to Supreme Court? Supreme Court takes longer time to dispose of the matter than High Court. In High Court, generally, I have seen within 1 year, your petition gets disposed of. But in High Court, Supreme Court takes longer. So why would you go to Supreme Court if you have a remedy in High Court itself?
Sir, is it possible to go to Supreme Court without a fitness certificate from the High Court?
Those I'm not practicing in Supreme Court, sir. I may not be able to answer right now. Maybe I can find out.
Fine,
in person, I can let you know.
Okay, Ganesh sir, one more question. We were discussing about this predetermined issue, right? So there is consider a situation where a particular transaction is alleged as taxable in pre-GST regime, and now it is before High Court or Supreme Court. Now the same issue is coming up in GST, where the taxpayer is of the opinion that that particular transaction is not liable to tax or something of the sort, and he has not paid the tax. So will this particular in this particular situation, can we say that okay, SCN has predetermined the issue, or okay, if they happen to issue a SCN, will it be advisable to go to the same forum where the matter is pending in pre-GST, say High Court or Supreme Court, or should we? What is your view?
So according to the law, if the SCN is valid, if the SCN is issued under GST, and if it is if something is wrong with the SCN under GST law, you cannot relate with service tax. Service tax law is different. Some principles you can borrow from service tax law jurisprudence, but GST law, if it under the eyes of GST law, if it is SCN is valid, then you have to you cannot approach High Court.
Okay,
If it is
perfect.
on the other side, you can definitely.
Okay, thank you.
So adjudication at the stage
Ganesh sir,
of
sorry, one
Yes,
more
sir,
question.
Yes, sir. Yes,
Okay,
sir.
sorry. Okay, so now consider that the High Court writ has been opted against the SCN. Now, what would be the fate of SCN? And between the time I admit the writ gets admitted, if the show cause notice has converted into an order, should the order wait, or the SSC should parallelly be handling both the procedures?
Actually, sir, once SCN is issued on the face of it, if it is wrong, we approach High Court, questioning the
Correct.
jurisdiction, whatever exceptions. In the first hearing itself, ask stay on the operation of the Supreme Court. If there is a complete stay on the operation of the Supreme Court, it stops. It doesn't go further. They cannot go further. The limitations stop there
No,
itself.
but is it at the time of admission of the filing of the writ or writ being admitted?
See, when we file petition without hearing the other side, they can give the interim stay. They will issue the notice to the other side, and if it is a fit case for giving stay, they will give stay based on those exceptions and whatever I quoted. They will give the stay and they will give the notice to the other side to come and appear next time. Till the next time,
Right.
next date, there will be a stay on that operation of the SCN. In the next date, hearing will again continue, and they may question, they may challenge stay on the SCN. And that need to be countered by petitioners council. And
So
if we
that means
succeed, then
till the date of filing of the writ. So it is not about admission of the writ. If till the date of filing of the writ, if the order is not passed, then the SCN gets temporarily suspended.
so filing is not sufficient, sir. Legally, you have to get the order of stay from the High Court, because we have seen in High Court.
No, I'm saying
yeah.
no. If I filed, then they might call for the other party for hearing.
Correct.
They may hear and admit the writ or dispose it of saying not tenable.
Correct.
Now,
So,
in the interim stage, can an order be issued against the show cause notice? The answer is no, right?
No, order can be issued only to stay the operation of the SCN, not on the merits, not on the issue, not on the controversy.
No, exactly. So, my only question is, can the proper officer go ahead and issue the order parallelly as the High Court proceedings are happening?
No. Well, if the stay is in operation, he is legally bound to, respect that stay and do not do anything further.
Right.
Okay, otherwise it's a contempt of court proceedings can be initiated against that officer of the department. So the matter, once the matter is sub judice before the court, okay, and you have a stay, then officer cannot move, cannot go further. So filing the petition, yeah.
Got it. So now, in a scenario where by the time I have filed my writ application, because that itself will take at least 15 days, a month, by the lawyer to understand and everything, and an order got passed. Will I still go against the SCN, or now I'll drop my writ against the SCN and I'll start going the writ against order?
You have to go against the order then. At the time of filing, if your order is already issued, then you have to, your petition will be against the order. You have to make out a case. This order is wrong. SCN is wrong. Order is wrong. So before order is issued, you have to make sure you file a petition. So my experience, if I don't have time, I make a very, very brief petition. I don't spend 15 days, maybe 1 or 2 days time I will spend and make a petition and file it. And request the court's leave to accept my additional submissions later on. So if I don't have time, I do that strategy is adopted by many lawyers actually. We don't have time. So before the order, you have to approach High Court and get the stay. And the moment you file a petition, you may not get stay on the next day. By next day when the matter is heard, you may get stay maybe 2 or 3 hearings later. In the meantime, there is a risk of officer going for order. you need to inform the officer immediately that you have filed a writ petition. It is not mandatory on his part to obey that request of yours to not to do anything, but he may go ahead and do it if the stay is not granted. Income tax authorities generally they respect if the petition is filed, they don't take any coercive action. But GST, I have seen practically without stay, they have gone ahead and did the attachment under 69.
So the
So
deemed
now,
stay provisions which is there under 107 and 112. So even when writ is filed, that deemed stay doesn't operate now. Sir.
Sorry, madam, I didn't get your question.
No, I mean in 107 and 112, we have once pre-deposit is made and appeal is filed. For the balance demand, it is deemed the deemed stay provisions. I mean are operative because of the express provision in the law.
Yes.
Unlike these provisions, one approaches for a writ remedy. This benefit may not be available.
Correct. You are right. You are right. There is no express stay. There is no implied stay by filing petition. You need to have express stay from the court. These stays are given not for a life. They are given only till the next date of hearing. Every time you have to renew this stay, you have to keep. It is a moving target. Every hearing you have to ask for further extension of the stay till the next hearing. So if I go to the next slide, adjudication stage. These again we will be confronted with a similar kind of exceptions. What we have seen at the SCN stage. So these grounds or exceptions, some of them can be overlapping or repeated in order stage, because we can go at the order stage also. If your adjudication SCN, you participated in the SCN, you gave a reply, submissions, documents, proofs, and none of your submissions are considered, etc. An order is passed ex parte or without giving regard to your submissions, then at that stage also you can approach High Court. And these are some of the exceptions which are kind of a repetition to the earlier. First one is violation principle of natural justice, violation of fundamental rights, error of law apparent on the face of record, non-application of mind, and alternate remedy is onerous or burdensome. It is futile to use alternate remedy. No appeal lies from Kaiser to Kaiser's wife. So these are kind of exceptions. These have their own analogy or philosophy or theory behind each of these exceptions. Depends on the facts and situation. We can understand what these exceptions could be. If I have to say alternate remedy is onerous or burdensome, paying pre-deposit 10% or 20% as the case may be itself is huge because of the huge demand. Infosys got 32,000 crore demand, for example, in SCN. It may be difficult for them to pay 10%. In that case also you can approach. There are cases in the past which held that Supreme Court itself, which held that if it is burdensome or onerous too much, then you can approach High Court and seek relief on the stay on the demand proceedings. Futile to use alternate remedy. If there is an order from the government itself to the authorities, okay, do this way only, adjudicate these matters only this way, then in view of those instructions or directions of the government to the authorities, officers, it's a futile exercise to go and approach them for a remedy under statute. In these cases can be made out at the order stage also. You can approach High Court and impugn the order. Appellate order. Once you are issued with appellate order, again there is a this thing typo. It is not 109, it is 107 before first commissioner appeal under GST. So again there are exceptions. After the appellate commissioner, you go through again the same cycle. You file a APL 1, make your grounds, attend personal hearing, and give submissions, documents, this, that, all that happens. Then you are again ended up with no real remedy. At that even at that stage, you can approach High Court, but you should have again a strong case. Right now, a lot of High Courts are flooded with writ petitions because of GST tribunal is not formed, and there is no efficacious remedy available under the statute to challenge the first appeal order. So the first exception is GSTAT not yet constituted. This is the present case. Maybe this may not be a case in future when GSTAT is available. Ex parte rejection of order for non-payment of pre-deposit. There are cases where you don't need to pay pre-deposit because there is no demand on the tax. There is a demand of penalty or interest. In those cases, if you don't pay pre-deposit, they dismiss or reject the order. Those cases you can approach the High Court. Ex parte rejection of order for limitation. So 107 limitation is a question of law and fact. What is the date of service, communication, all those questions will come to play. And where you think that you are covered by limitation, but they think, department thinks you are outside the limitation. That's why appeal 107 APL 1 is dismissed. That also can be a ground. You have to go and agitate before the High Court and inform when did I receive order, all those things with data points and evidences. Violation of the principle of natural justice is a very famous ground. Violation of fundamental right, error of law apparent on the face of record, non-application of mind by the officer. It's just a stamping exercise which the appeal commissioner does without applying any mind. Not convenient, beneficial, or effective. Long back in 1955, Bengal Immunity Club case, in that case, Supreme Court said this: if the remedy available in the statute is not convenient, beneficial, or effective, that also can be a ground. And this exception can be you can apply to against OIO, order in original also, adjudication order also. You can use this ground. Then the last but one, alternative remedy is onerous or burdensome. This I already covered. Pre-deposit is too huge or 100% pre-deposit in certain cases. If you're asked to pay in income tax, you may be asked to pay 80% of the pre-deposit of the demand or adjudication demand. If that becomes very huge or high pitch assessment, they call income tax. Those cases can be in those cases we can approach High Court. It is futile to use alternate remedy. You know that the result outcome of your statutory appeal is going to be what it is going to be based on facts. Then there's no then those in that case also you can approach High Court. So there are few cases on the maintainability which can be a hurdle, or it can be maintainability is a big question actually, which is confronted by any advocate, because there is a danger. A lot of hard work goes in preparing the petition, filing it, and at the end, in 2 minutes, it gets rejected or dismissed based on maintainability ground. Which we have already covered. Maintainability is subject to exceptions, which we have discussed in brief already. There are few case laws I wanted to highlight just to bring out the point. What is the what judgments of the Supreme Court have said about maintainability in the past. The oldest case is State of Uttar Pradesh versus Muhammad Noor, 1958 judgment. It says that one place it observes that rule requiring the exhaustion of statutory remedies before the writ will be granted is a rule of policy, convenience, and discretion, rather than a rule of law, and instances are onerous. Will I need another 5 to 10 minutes max? I hope it is fine.
Please go ahead and complete it, sir. No issue.
Yes, sir. The rule of policy, convenience, and discretion, rather than a rule of law, and instances are numerous where a writ of certiorari has been issued in spite of the fact that the aggrieved party had other adequate legal remedies. So this is the example where it gives a leeway to the petitioner to approach, writ remedies. This is in the context of certiorari writ, but as I said already, it's a discretionary power of the courts, and it is the rule of policy, convenience, or discretion of the court to decide whether this matter to be admitted under 226(32) or not. So this has been referred subsequently by many people and is considered by the courts while admitting the petitions. Wonderful is a latest 1998 judgment where it observed that where the writ petition has been filed for the enforcement of any of the fundamental rights or where there has been a violation of principle of natural justice, or where the order or proceedings are wholly without jurisdiction, or the virus of an act is challenged. There is a plethora of case law on this point, but to cut down this circle of cornices Wolful, we would rely on some old decisions of the evolutionary era of the constitutional law as they still hold the field. So the philosophy or the jurisprudence around admission of petitions is there a case of fundamental right violation? First, is there a case of violation of principle of natural justice? Number two, and then whether it is wholly without the jurisdiction. Jurisdiction we already discussed. If it is outside the jurisdiction, then it's definitely a strong case, a valid case. And virus of the act is challenged. If you are challenging the virus of the provisions of the act or act on the plank of constitutional provisions or fundamental right provisions, then there's no case for court to not admit the petition. No matter at the end, it may dismiss. Like 16.4, people have challenged the provision of 16.4, 17.5, Safari Retreat. All these cases are admitted because there is a challenge on the virus of the act. And the petition, when we are filing a petition, we are required as per rules, at least in Karnataka, to specify whether I am challenging virus of the provisions of the act or not. I need to expressly put it in the petition clearly, so that it can be taken note of to decide the admission or otherwise of the petition. So the recent case is this Godrej Sharali and Excise, which is also referred by our own judge, Justice Krishna Dikshit, last year, who relied on this and said that alternate remedy, in very colloquial language, he said it is doctrine or alternate remedy doctrine, which is used as a tool or weapon by department councils. It's not a China wall. It's not a rigid wall against the invocation of writ jurisdiction by the court. So going to this judgment of Godrej, if I have to read that paragraph, the final orders impugned in the petition were passed upon assuming a jurisdiction which the revisional authority did not possess. In fine, the orders impugned were passed wholly without jurisdiction, since a jurisdictional issue was raised by the appellant in the writ jurisdiction, questioning the very competence of the revisional authority to exercise suo motu power, being a pure question of law. We are of the considered view that the plea raised in the writ petition did deserve a consideration on the merit. An appellant's writ petition ought not to have been thrown out of at the threshold. So what it is trying to say is, it's again a question on the jurisdictional issue. The revisional authority did not have jurisdiction at all to do the revision as per the law, but still he went ahead and done it. But the High Court has rejected the petition on the ground of alternate remedy. So Supreme Court said this is a question of law on the jurisdiction which was raised by the petitioner Godrej, and this should have been admitted and accepted because it needed consideration on the part of the High Court. So this is the the important observation which is used by petitioners in many cases where there is a jurisdictional issue. Then GST matter, one more, Radhakrishna Industries, State of Himachal Pradesh, 21, where Justice Chandrachud had made very beautifully written judgment. One of the paragraph where he says the jurisdiction to pass an order, it's a very I would say very sensitive or very difficult a thing which was very difficult to observe, but it went past High Court. High Court rejected the petition after it reached Supreme Court. After doing a critical, clinical analysis of the provisions of Section 83, which is a provisional attachment, court said that although the power stands delegated, among the other contentions of the petitioner, this was also a contention that High Court has rejected the petition on the threshold, where Supreme Court said that although the power stands delegated to the third respondent joint commissioner in section 83, the order still is deemed to be passed by the commissioner, second respondent. Under the GST Act, an appeal against the order of the commissioner lies before GST Appellate Tribunal, which has not been constituted till date. Thus, the only remedy available to the appellant was by filing a writ petition. Here, the matter was section 83 used powers to the commissioner to do the provisional attachment and not to the adjudication officer, which is referred in 107. Here, because the commissioner has done it, and commissioner action, there's no provision to go for 107 appeal to appeal one if commissioner issued this order, section 83 order. Only remedy available is to approach GST tribunal under 112, not under 107. So this was the very fine, observation which was done by Supreme Court, which is very relevant. Thing is, we need to keep our minds and eyes and open to get things. Section 83, anybody would have thought section 83, if I get a provisional attachment, can go and get the provisional attachment stayed or challenged, but that is not the case. So Radhakrishna Industries, I don't want to go into this slide. This gives a 5 broad parameters under which alternate remedy can be bypassed, and these can be kind of a Bible which one can follow to decide whether High Court should be approached for any of this SCN or order or first appellate order issued by the appellate authority. So these are common issues which I could pull out from various case laws where petitioners, taxpayers in GST have approached high courts. 2A, 3B difference, Suncraft Energy in Calcutta High Court, DY Bittal in Madras High Court, Loknath in again the Kolkata High Court, DI agencies in Kerala High Court. These are, yes sir.
Sir, these cases have reached the High Court after the orders got passed, right? Because there is no alternative remedy was available.
No, I'm not on that point, sir. Only the matters GST litigation. Doesn't matter which stage, from which stage they travel to High Court. But these matters have reached High Court and they have been admitted.
Is there any matter which went to High Court on at the SCN stage? Do we have any case?
SCN stage, I think that Gamescraft, if I remember, I don't know whether it's SCN only. And there are small petty matters which I keep hearing from the court where people come with the SCN itself in their hand. I'm given a SCN which officer doesn't have jurisdiction. My fundamental rights are violated. All these grounds are made out. Get the petition admitted. But Gamescraft and there will be, if you find out, we'll get. It's a valid SCN stage also you can approach High Court, but it's risky. It's a little risky, but going to High Court. But yes, you can.
When I said that show cause notice only, Gamescraft, you're right.
Yeah. So tax on mining royalty under RCM. Lakhvinder Singh, Udaipur Chamber of Commerce, recently Supreme Court has delivered a judgment on this also. Lakhvinder Singh was a GST issue, Udaipur Chamber of Commerce also. The main matter was some other government authority, I think Tata something. There, this matter got GST issue also got tagged into that case, and finally it came up with some judgment with the retrospective effect of state government giving powers to state government to invoke to collect royalty from the miners from past date. Delay in filing 107 appeal. So if you don't file appeal within 4 months, 3 months plus 4 months, and there is a genuine ground and your appeal is rejected, you can go. People have approached High Court base judgment assessment order under section 62, cryptic order under 62, or without considering that 2 months time to pay the tax and any those issues, base judgment assessment was not done in accordance with the circular, some circulars than GST. If those principles are not followed, and that 62 order ASMT 13 or 12, 10 something doesn't contain all the details of the assessment, how he has arrived at the assessment amount, dispensation of pre-deposit, which I explained in confiscation or detention of vehicles and goods cases, if only penalty is demanded and you want to challenge that, you don't need to pay pre-deposit, because 107 pre-deposit is on the tax, not on other components, and still their appeals are rejected. And cancellation of registration, these cases are replete and everywhere, registration cancellation. So generally, general view taken by high courts is to allow the registration unless there is a very serious, case of not granting registration back or revoking the cancellation of registration. Revocation of extended period of limitation under section 74, where those, suppression, fraud, etc., those are not made out. Those are not it's a case which doesn't make out. It's a fraud case, and still the extended time limitation is given. I think right now under the amended world, I don't think that differentiation is there. I don't want to comment on that, but under service tax law also, there are a lot of cases on this under 73, provision to 73 of Finance Act, where fraud, just for the sake of saying there is a suppression, is not sufficient in terms of 1053 circular of service tax. There are a lot of things to be proved. Detention, confiscation of goods, this I already covered. Order passed without issuance of SCN of 73 or 74. There, I don't know. I don't have any case with me, but there are such cases where without issuing SCN, the orders are passed. Maybe SCN is not reached or not delivered or not issued properly, not recovery during pendency of 107 appeal. So without waiting for 3 months time, or without that, proviso to 69, if I remember, is invoked, without waiting for those 3 months plus 4 months time for preferring appeal. If some recovery action is taken, definitely you can approach High Court. Provisional attachment of bank account under 73, 83, we have seen this. Non-reciprocation or preliminary objections raised under section 6710, inspection, search, seizure in line with CRPC provisions. If 67 investigation is done, this is subject to CRPC provisions and all the procedures which are laid down in that law has to be followed as if he's a police officer who is doing some adjudication of criminal matter. If all those that procedure is questioned, your INS1 is questioned, then without giving proper without doing proper adjudication of 67 proceedings ended with 74 notice, you can approach High Court and question whatever preliminary objections I have raised for investigations which is carried out under 67. There's no response or no satisfactory reply given by the officer who has done the investigation or adjudication. Then also there are cases where the relief is given in terms of stay and directions given to the other side to furnish all the documents, papers, explanations which is sought by the petitioner. The last slide is on the basic homework, basic housekeeping points which one need to keep in mind. These are not exhaustive, but only main ones which I tried to put out on this slide, which one need to consider and respect, and then only think about it petition. So clean hands before going to High Court. You need to be out of any kind of guilt, fraud, bad faith acquiescence, or should not be a vexatious or frivolous or speculative claim just for the sake of staying the demand, or should not be a such case where your intentions, we call mens rea. Your intention should not be to defraud the revenue or cheat the revenue. The case should be strong enough to get the relief under for violation of fundamental rights or any of the legal rights which you have under the statute. Cause of action, legal injury. So this is a prerequisite, sine qua non for approaching High Court. Unless you are injured legally or under Constitution, you don't have a right of asking a remedy under 226. You should have, just because apprehension I covered in the SCN slide, just because you apprehend that you will get affected by this SCN is not enough. You should have already, only after you met with accident, you go to hospital. It's kind of a analogy you can apply here. Locus standi, infringement of legal right or prejudice to legal interest. So unless you can't fight for somebody else's cause, you should have been affected. It's only you. It's not a PIL which you are filing. You are filing a petition in your for your own cause. Limitation, as I already covered, there is no Limitation Act is not applicable, but courts take into consideration Limitation Act liberally, not strictly. Okay, and cases where there is a they are crossing the limitation period which is given in the Limitation Act, still they consider. For example, for filing writ appeal, there is a 30 days time under Limitation Act. Okay, that they sometime they dispense with that, depending on the situation, depending on the facts and the situation of the case. So it doesn't mean that if the time limit is 3 years under Limitation Act to prefer to seek some relief, you should wait for 2.5 years or 29 months, etc. You need to approach High Court as soon as possible. Okay, so it should be, they should get convinced that you are a vigilant and very person who is really injured, who is approaching the High Court. No existing appeals petitions pending before any other forum. This is called forum shopping. If you are approaching High Court, there is a disclaimer or a undertaking you need to give in the petition itself that I have not, for this cause, this issue, I have not filed any appeal or any application before any other authority. It is not pending anywhere. This is the High Court, this is the Honorable High Court where only I am approaching. There is no other pending matter. So if you are having a pending matter in the tribunal, you should not be approaching High Court. Okay, having already gone to tribunal, you need to wait for tribunal to dispose of the matter. Then only you should go to High Court. No disputed facts. This is important one. See, as I told already, High Court is not a fact-finding authority. It will only talk on the process followed in adjudication or issue of SCN. It will not go back on the merit of that controversy issue of the tax amount, classification, all those things. It will only go on the process followed, whether it is right or wrong. Okay, if the basic facts are not not aligned or not agreed or under serious dispute, matter gets remanded back to the officer again to re-adjudicate, or they'll dismiss the appeal, dismiss the petition. So where there are complex, like investigation 67, there is a complex question of facts warranting oral evidences by different people. There is a right to cross-examine the other side. Department has done investigation and take the summoned people, different people. There is a right conferred under Constitution itself on the petitioner, on here the taxpayer, cross-examine the other side, people who are summoned by officer. If these kind of cases, if these are all required to reach to the final conclusion of the controversy, those kind of cases are generally they're not admitted, or they are not taken by High Court, where there's a oral evidences are required. So these are to be done by officers. You need to approach the commissioner appellate authority, appellate route, not through High Court. with this, I end this my presentation. Apart from whatever question Q&A we had in between, if any other things are hanging, please let me know, and at this time my best to answer.
Thank you, Ganesh sir.
Welcome, sir.
Any other questions from anyone before we go to the next session?
Ganesh sir, just as a matter of interest, any writ or any writ petition that the department has preferred, I guess, against any of the taxpayer or any instances or any previous cases? Is it possible in the first instance?
Department is a government. It's an extended arm of government. Writ petitions are filed against government, not by government. They can file appeal, statutory appeal. They can file under 107 and 112. They can file appeal, but writ petition.
No such cases, no, in previously.
Writ appeal they can file. They can file a statutory appeal to High Court under relevant section of GST law 260A income tax. They can file appeal, but this is to safeguard the fundamental rights, uphold the fundamental rights of the citizens of the country. Government is not a citizen. Government is the welfare state. Is responsible for the safety and welfare of the citizens, of common citizens of the country.
Okay.
Okay.
Thank you.
Ganesha, one question I have.
Haji, madam.
Yeah, so like generally, what are the mistakes which are made because of which writs does not get admitted at the first instance? I mean, from some practical insights, like tend to miss out certain things before approaching writ remedy.
We may have a strong case. The exceptions what I discussed, no, you may have a strong case, but it is not sufficient to have that case. You need to communicate. It need to go into the minds and heart of the judge. Your communication, your petition copy, more than petition, your oral submission when you're heard. That makes a lot of difference. You should, as I said, your what do you call, hurt, where you are hurt, how you are hurt, that should be made known to the other side. If your officer doesn't have any jurisdiction at all, and income tax matter, if I have to tell you, there is no percentage minimum, there is no percentage on pre-deposit to file first appeal before commissioner appeal, and there is a wide power given to assessing officer, PCIT, his boss, to decide how much pre-deposit to be collected in terms of some circular. There is no statutory provision. Sometimes they say you have to pay 50%, which is arbitrary. In that case, PCIT just rejects your application and says that you have to pay 50%. In those cases, you have to make a strong case. You have to show your financials, details, whether you are financially or capacity is there to pay this amount. If you are just saying, trying Hail Mary before them is not sufficient, madam. You need to have database, data points, evidences to show that you have a strong case. And these exceptions must be the Bible, actually. You should be covered by these, and you have to expound these further before them. They need to get convinced. It's not a machine. They are all human beings. They need to get convinced. And to get them convinced, you have to. I see in the court, people go there, with a hurry, without thinking about remedy. There are many cases. Last week only, I saw one case, service tax law case. They just thrown the paper out. Why you came here? Sometimes they are rude because of their dispassionately they work and frustration. They try to show something. So it's our duty as a taxpayer, advocate, or CA to make sure we don't go to high court. It should not go directly because it is a waste of effort. So, if you know that it is not going to sustain, better not to go. I am telling this as a lawyer. It will earn fees for me, but that is not suggestion I give to anyone.
Ganesh, I think it was a very detailed deliberation. I think some of the my experience of the High Court writ, I would like to share and which I think would also would answer many of the questions and discussions which happened a little while ago. Firstly, as you rightly mentioned, the writ petition is where to question the process, not the issue. That is what we fundamentally. And Puna, you're asking, no, that what is that we need mistakes which we do. Generally, we have a tendency of appeal in our mind. So some wrong decision. So we cannot question the wrong decision be in a writ petition. We have to question the wrong process of decision making, not the wrong decision in a writ petitions. Or I think the various other factors did mention. So generally, again, one more important thing which we need to keep in mind, High Court will not get into the facts. We cannot go on explaining the facts, though certain relevant facts has to be brought out. But I think they will not get into a disputed facts decision making. If there is a dispute on a facts, I think they will not, get into. And we need to also know court has a wide power to go beyond the proceedings and order for anything else also. So we need to be very cautious. If there's already errors and mistakes in the notice and you want to take advantage of that, if you're going to High Court, then you may probably lose that right, because High Court may remand and ask them to re-examine the entire thing, do an entire reassessment, all those things. So you need to keep that aspect also in mind. Whether it is proper, I mean, it would be advantageous to go to writ petition or to go in things where certain of your rights gets protected in the normal, adjudication and appeal proceedings. And sometimes in a writ petition, especially these 2A, 3B cases, I'm just telling very lightly 2A, 3B cases, where you can also bring the other party also onto the record. Ganesh, correct me if I'm wrong. I was given to understand, say that, supplier X has supplied me a goods and has, I have procured, I have availed the input tax, I have paid everything, but he has not paid. Department has not initiated any proceedings. So we can make him also a party so that he will also come to the court and explain whether he has paid or not paid. If he has defaulted, court can always ask the authority to catch him, not us. So that is also one of the things I got to know while interacting with advocates. One more aspect of Supreme Court, generally where it is a direction to a central government, which impacts beyond the territory of the jurisdictional High Court, then they generally approach the Supreme Court. Or for that matter, where the issue which is more sensitive and who can afford to pay lawyers heavily will go directly to Supreme Court. One advantage of High Court, as Ganesh was mentioning, High Court has got a wider power than 32. 226 is having a wider power than 32 because it can also go to other legal rights. So that is also one important thing which we can keep in mind. And High Court, when we go within a writ petition, it's an extraordinary jurisdiction. It is not a regular appeal jurisdiction, etc. So we need our approach and our what relief we ask. I think we have to be very careful and clear. And this pre-deposit aspect, to my experience and understanding, courts generally will not entertain that as a ground to admit the writ, unless it is shown clearly that there has been a gross violations of principles of natural justice, or the orders were passed ex parte, and they have taken the entire balance sheet turnover and demanded tax. I mean, entire P&L turnover and demanded tax. And they have not supplied all the relied upon documents. So these are the instances when, and in spite of you requesting for documents, and you have been asking for some cross examination, etc. They are not giving a cross examination, and orders have been passed. So these are some things where you can, and in fact, while interacting with many of the advocates, they say for admission of a writ against the show cause notice, generally they will find if they can challenge some of the provisions itself. If they challenge the provision, then generally at the show cause notice stage, if you are any of the provisions, if you are challenging, I think they tend to admit the writ petition without asking for an alternate remedy. This is what I was given to answer. I don't know to what extent is true. This is one more way the advocates actually work upon, is what I was given to understand. I think these are some of my limited inputs and experiences I thought I share. It may have help to all.
Just to 2 points, sir. Challenges virus of the statute. Generally, we do that. It is done because some provision of the law is coming on your way, and you don't have sufficient grounds to fight out your case. Go and challenge the provision itself. You go back to the root and challenge the provision. If challenge goes, you get automatic relief. What you're seeking, like 17.5 Safari retreat, they challenge the provision itself. So the ITC was allowed, subject to Supreme Court's. It is pending before Supreme Court.
No, I think unfortunately High Court did not quash a provision. They read down the provision.
Okay, correct. And the other aspect is about impleading the other party in 2A3B. The Safari retreat, they also impleaded the sellers, suppliers. Problem is the suppliers, they already decided not to defraud the purchaser, and making them, impleading them may become difficult for you to carry on with your case and conclude your case, because they also need to be given opportunity to be heard and come before the court and agitate and defend themselves. That takes time. If you only make the government as party, their advocates are always available on the bench. They are always available in the court.
Yeah.
Including the private parties is only point is it will be a little bit time consuming thing. Your petition will get delayed if you plead them, private parties. And the court also may say, why are you pleading him? It's a contract. It's your contract. You go and approach your civil court and under contract law and ask for relief there, not here. There's a risk. So in my own cases, I did not implead these parties, keeping these risks in mind. I wanted expedited disposal of matters 2A3B. So that's right. Thank you.
Yeah.
Sorry in case there is anything wrong, please forgive me. I'm just 1 year old in law practice. I'm not a very experienced seasonal professional. Whatever I learned in the last 1 year, I just try to put it across in front of you. Thank you so much.
Thank you, sir. Annapurna, can you share your screen?
Yeah. Can you enable me to share the screen?
Yeah, you can.
No, I could not.
Try.
Now I can. Yeah. Visible, right?
Yeah.
Okay. Yeah. So during the previous session, we concluded, up until here as to, some of the major provisions, the amendments through the finance bill for the GST law were discussed. We covered 11A, 128A, and 74A, and some more major provisions we covered. Now, I'll be taking up the balance provisions. I might need some maximum 20 minutes of time to discuss on these things, because majority of the provisions we have covered in the previous session. Now, firstly, the levy provision itself is proposed to be amended, wherein the ENA or the rectified spirit used in manufacture of alcoholic liquor for human consumption, that is to be treated as non-leviable to GST. Of course, this is not product specific. This is apart from being product specific, it is purpose specific also. Only if the usage of this particular product is with respect to manufacture of alcoholic liquor for human consumption, only then this would be this would not be subject to the GST levy. Of course, when this is this appears to be a prospective amendment to me and not retrospective, and for past acts, probably 11A could be used to ratify the past acts. Maybe, I mean, that is thought process. Anything to discuss on this, or can I move to the next provision?
Please move.
Yeah. So the next provision is 13.3 subclause 2 clause C, where with respect to services, RCM services, the time of supply is specified to be the date of issue of invoice by the recipient in cases where invoice is to be issued by the recipient. Basically, this covers situations where the services covered under RCM are received by, the supplier is an unregistered person, and RCM is discharged, and self-invoice is raised by the recipient. Interestingly, this provision says that time of supply is the date of issue of invoice by the recipient, not the date of, issue. Rather, let's say if there is a delay in issue of this invoice by the recipient, does it also postpone the time of supply for based on the date of issue? Does it mean that interest will not apply? I was just wondering, is it like by slip they've mentioned it so, or what could be, because then it gives control to the person who is required to discharge RCM. He can decide the time of supply based on what date he issues the invoice, isn't it? And also, we don't find a corresponding amendment in section 12 for goods. So I would like to, invite members' views on this.
Isn't it to be read as saying that the past, since there is no provision in the law, we are saying that the time of supply for service is only when the self-tax invoice would be raised. But now they have explicitly amended 13 and 31 to say that the time invoice, self-tax invoice has to be issued by so-and-so date. So they brought clarity to it.
Correct. So 13.3F will prescribe through rules, again, and a connecting rule to 13.3F would be given, wherein they would say that within which period, so by when the time limit for issuance of self-invoice is provided in 13.3F through a rule. Now, okay, so what if I delay issuing that invoice? It doesn't say that time limit prescribed in 13.3F.
No, it says
date of issue of invoice. I'll just open that provision.
Anpurna, can you just open the entire provisions of 13.3?
Yes, sir. 1 second. So if we look at here, it says in clause B, by the supplier, for the words by the supplier, the words by the supplier in cases where invoice is required to be issued by the supplier, or there is a clause C which is inserted, date of issue of invoice by the recipient in case where invoice is to be issued by the recipient. It only says date of issue, which is more like actual date of issue of invoice. So isn't it like giving control to the recipient to decide the time of supply for RCM, where he is required to raise a self-invoice?
It is earlier of ABC, right?
Earlier, no, madam.
Earlier of ABC, right?
Earlier.
Yeah.
So which means now
Earlier, no? So either of these three.
it is now kind of putting rest to the problem, saying that even if you're delaying issue of invoice,
Huh.
so because all this while we were referring to the self-tax invoice.
Correct.
Now, you cannot take that plea that the self-tax invoice is issued only now. It is now it is earlier of all the three provisions.
Yeah. So like here, the date of issue of invoice by supplier. So first provision covers
the
when
RD.
from a registered supplier perspective. The second date of provision, this is more a subjective aspect because it's a service.
Or the date there is a payment.
Or so.
Ankuna, you are referring to subsection 2. I think
Oh, sorry,
this is
sorry.
3, no?
Sorry. Yeah. Huh. See, B covers basically supplier.
Yeah, RD.
Huh.
A is important. A
is accounting.
So either you made the accounted the expenditure or made the payment, or now they issued the invoice, whichever is earlier.
So the payment in the bank would also act as a trigger point here. What exactly is this provision doing by the insertion of this provision?
I think that B and C, they are segregating into supplier invoices and the recipient invoices. That's all.
Yeah, so this clause B is applicable only to supplier. So doesn't,
and they created clause C for recipient invoice.
For recipient. For recipient, it is, I think then date of, so only clause A or clause C, that is the comparative you would get for
the unregistered supplier. For registered supplier, clause
A or
clause
B. A or B. A or B or A or C.
Yes.
So that 60 days will only be for the registered supplier.
Yes.
So making of the payment becomes, I mean, that gets retained as it is even after this amendment.
I think now that you have to raise invoice, that the time limit is being set out in the rules separately for RCM.
Yeah.
So that fits in.
So if we just compare this 13(2) here it says issued within the prescribed period in section 31. But that kind of amendment is missing for 13(3), no, sir? So even though 31(3) has some prescription, that has not relevance to 13(3)(c).
They will always interpret that, the date of the invoice should have been there. So your last day has displayed there, then it will lead to a dispute. And you also have to get some cases, no? So they have created some provision for you to have these cases.
So basically A would prevail in most of the cases because payment would be a criteria.
Many times it may not be, a payment may delay. So in that case, this will be of some help.
So this way gives us more time.
And but anyhow, that book entry, date of payment as entered in the books of recipient, or which because here and also there is a provision which you need to keep in mind as well in subsection 3. Not possible to determine, then the date of entry in the books of account of the recipient.
So this is again limited to A or B. Corresponding amendment, okay, it's there in C, in the first proviso. So clause C also inserted. Yes, sir.
I think we can proceed.
Yes.
Unless you have anything.
Yeah, nothing. Yeah. So again, 13.3F, there is a provision now that rules would be prescribed for setting up a time limit for self-invoice. And they've inserted an explanation saying that PAN-based GST registration is treated as unregistered. And hence, the implication is that self-invoice has to be issued by the recipient with respect to this PAN-based GST registration RCM services received. So once it is prescribed in the rules, the time limit, then will it invalidate the ITC claim itself, sir, if it is a belated self-invoice is raised?
You are now merging two provisions. So you are taking from 13 to 16.
36, rule 36, yeah.
That is not altered, no? That position is intact, no?
No, see, it says that underlying document should be self-invoice. So
Correct.
so there is no change that self-invoice issued within the prescribed time. So this will only give a room to levy penalty for a violation. That's all, no?
Interest and penalty will be from the date when it is the time of supply.
Yeah, interest
ITC
we
is
will
from
refer
the
to
date of
13.3.
Exactly. ITC is from the date of the invoice. No? Those positions not altered.
Yeah, so what if I delay raising a self-invoice beyond what would be prescribed in the rules? What are the repercussions out of that? Definitely, it will not invalidate my ITC claim. It will
Correct.
not even lead to interest repercussion because this has no relevance to 13.
Why?
At best, only penalty.
Interest would be applicable. That's what I'm saying. 13.3, the time of supply dates to the payment or the invoice, whichever is earlier.
Yeah, so I have see that anyways, for that we will visit section 13. Now, on a pure basis, if we are looking at 31.3, where I am issuing a belated self-invoice,
Interest would be applicable is what I'm saying.
even otherwise, I mean, see, okay, now if I fall in clause A, what we discussed now, date of payment, but I raise a belated invoice, then yeah, so that is there. Okay, I mean, this express change in 31.3F, what it is giving an implication, like it will only enable contraventions of provisions of law and hence penalty, no?
No, 31.3F saying even for the government, you treat it as them as URD and you raise
That is explanation. No, I'm just telling 31.3F, where time limit is prescribed, no? Here, after the words of section 9 shall the words within a period as may be prescribed. Yeah, looks like just giving a specific room for levy of penalty, like a contravention basically. So, okay, I'll move next. 17.5I. So, tax paid owing to section 74 alone is blocked. So, but 74A is not inserted over here. So, subject to 2B, even belated tax invoice can credit be claimed. So 129, 130 is removed. Section 74 alone, that too up to 23, 24. They did not make a corresponding 74A amendment here. Does it mean that from financial year 24-25 onwards, even a 74A credits, I mean, tax payments made owing to 74A credits would be available? Because of the removal of this or non-inclusion of 74A over here? Rajesh sir, any specific thoughts why they have not put up 74A here?
Where am I? Yadರಲ್ಲಿ?
17.5 ಅಲ್ಲಿ
I think they've specifically excluded, because I think when we last time when we discussed the restrictions are they don't want to put a restrictions for the recipient to avail ITC. So the effect of that conditions is becoming redundant after this amendment of 74 and 74A.
Sir, ಇವಾಗ 74A ಅಲ್ಲಿ let's say pre-notice consultations or ಶುರು ಮಾಡಿದಾಗ this fellow will raise an invoice. Let's say it's a service.
Supplement invoice.
Huh?
Supplement invoice raise ಮಾಡಿದ್ರೆ credit ಸಿಗುತ್ತೆ customer.
So they can take the credit because 74A restriction ಏನಿಲ್ಲ 17.5
ಹೌದು.
ಅಲ್ಲಿ. That is
ಹೌದು.
only up until 23-24.
Yeah. So basically, ಈಗ notice but it's only limited for penalty. Notice segregation ಇಲ್ಲದೆ ಇರೋದ್ರಿಂದ they are removing that restriction to the recipient to take ITC. So you go on stealing the taxes unless caught, and you issue a supplementary invoice to the customer, and you will get the money anyhow, and only will be end up paying interest and penalty if you get caught.
Yeah, because 74A is a common section for both fraudulent and non-fraudulent cases.
Yes.
Maybe that is also one of the reasons they did not include that over here.
They can't include. They can't identify. Then you have
They
to
can't
get
identify.
into each. There will be a parallel proceedings in each case to determine whether the recipient is eligible for credit or not. On the one hand, you will be running the proceedings, and on the other hand, the recipient has to also parallelly run a proceeding to say that whether he is eligible or not eligible. So, and again, it is beyond the scope and ambit of the recipient to prove and establish whether the supplier has intentionally paid or not intentionally paid. And I am not a party to that proceedings. So how can I establish those things? So all these practical difficulties appears to have been considered, and they have effectively relaxed that provision in 17.5I.
So they're happy with interest and penalty. If tax credit to be taken, let them take ಅಂತ ಡೆಬಿಟ್ ನೋಟ್ ಇಶ್ಯೂ ಮಾಡಬೇಕು ಅಂತನಾ ಸರ್ ನೀವು ಹೇಳೋದು?
Supplementary invoice or a debit note.
Okay.
And there is no time limit, no sir. So let's say a 2021 case taken in 25-26. If the differential tax has to be paid, I raise a debit note now, put it in 2B instead of paying through DRC 03.
No, looking at it in a different perspective, many of the cases, the assessees in the audit and other proceedings, investigation proceedings, though it is not payable, why to take risk? They better pay interest and 15% of the tax as penalty, and anyhow, and close the proceedings. So the recipient will anyhow get an input tax credit on the same. So that
he can recover that also from that.
Yeah, the litigation requirements if he is eligible to take a credit. So the litigation will come down is a one more way of looking this entire thing, like a compromise between the government and taxpayers. This is having a wide repercussion to in a litigation cases.
Oh, so thank you. Next is like GSTR 7. They made it like even if it is a nil return, that has to be filed. So Venu sir, like are they making like we have 3B, you know, unless subsequent return filed, unless the previous return filed, subsequent return cannot be filed. So if they're intending that even nil return has to be mandatory file, are they introducing this sequential test?
Yeah, they would. Right now, as of now, no. Maybe I think in this month it would come.
So department files off mistakenly nil return. Then they have to include all the other things in the subsequent month, is it?
It has the amendment provision, no? Inclusion, same like GSTR 1.
Same like GSTR 1. Okay. Right. So I'll move to the next provision. 54, subsection 15 has been introduced. With respect to zero-rated supply of goods, wherein, you know, which is subject to export duty. Earlier, you know, there was restriction only with respect to without payment option, without payment category. Now they've made it uniform and included even with payment option also would be subject to the restriction of refunds. This appears to be like a prospective amendment, or is it a retroactive amendment? So because past refunds, definitely whatever refunds already received, it would be valid. And till this provision gets notified, those who have opted for with payment, they can continue to file their GSTR once accordingly, and they'll get the refunds of with payment option like before. So, would it be a retroactive, sir? Because let's say let's say this provision gets notified on 1st of September. Just hypothetically. So, whatever refunds applications which are filed till that point in time, or let's say somebody is filing a belated GSTR 1 even after that amendment. So, this would apply to that as well, or is it only a prospective amendment, or do we see that as a retroactive amendment?
As far as the goods are concerned, you need not file an application. No, it is at the time of shipping bill itself get automatically logged. So
yes,
whatever would have got exported after till the date of notification, they will get it.
Okay, so even if I file a belated GSTR 1 up until August, let's say on October, November, December, still I would get the refund because it is the shipping bill details which would be more relevant, and
No, the shipping bill is the day application, no? For on payment of tax.
Actually,
that is a deemed
GSTR
application.
1 filing of GSTR 1 is the application also.
No. Your shipping bill is an application. It is validated or correlated through GSTR 1. The rule says that that your shipping bill is whatever 18, and I think you can just check on.
I think 96.
Sorry, 96. I don't know about all these rules.
Yeah. Okay.
Many of
shipping bill,
the
sir.
members
Yes,
are
sir. Yes, sir. Yes, sir. Shipping bill, sir. So shipping bill itself is the application, sir. Correct, sir. So the date of shipping bill will decide the end of this with payment refund option. Yes, sir. Thank you. So anyways, the other amendments were 7312, 7412 will have obviously a sunset clause of applicability till financial year 23-24. And the principal bench of tribunal would be empowered for handling anti-profiteering matters. Corresponding amendment in 171 also has been made. And also some other matters which is to be heard by the principal bench will also be notified using this provision. Okay. And the penalty provision with respect to e-commerce operator, they've specified that the one who is liable to collect TCS only to such an e-commerce operator, this penalty would be applicable for obvious reasons as well. Then with respect to the transitional provisions, invoices issued on or after was the provision, but they have now specifically mentioned even if invoices were received prior, but all other conditions of this provision are fulfilled, even then the transitional credit would be available. And of course, in 171, we have this sunset clause of by a date by when the anti-profiteering authority would stop receiving applications in this regard. And also the authority, the word authority would include even the appellate tribunal. That this is the corresponding amendments we see in 109 as well as 171. And we have the Schedule 3 amendment where co-insurer, where the apportionment of co-insurance premium, and reinsurer, where the reinsurance commission or the ceding commission received, just to avoid the double tax once again. So if it is subject to tax on a gross value, then there is no GST again on this separated amount. The last amendment, what we see in CGST related amendments is no refund shall be made of all tax paid or ITC reversed, which would have not been so paid or reversed had section 114 been in force at all times, which is basically 16.5 and 16.6, 114 with respect to this 16.4 time limit, which is now being extended, and that too retrospectively. So they've inserted this provision that somebody who was already paid or ITC has been reversed, so then refund would not be available. Sir, they have introduced this as a clause in this Finance Act. So this will not find place in the Act, sir. It will only remain as a clause in the Finance Act, sir. Finance Bill as of now.
Which one, Amma? Yeah, the
Clause
section
146, sir.
of the
So,
Finance Act.
So ಇಲ್ಲಿ just clause ಇದೆ. There is no reference to any section.
ಹೌದು. This is not in the. This is a special provision consequent to the section 128A.
114 alva sir? 114
16.4.
16.4, howದು sir?
Because they're giving a retrospective effect, you cannot take a benefit of that retrospective amendment and claim refund. It is there as still as a part of a Finance Act only, not a. In fact, we had a lengthy discussion, myself, Venu, and all, where Venu was telling why it is not in the CGST Act. So, in fact, that is where we were bringing out the proposition. Finance Act is also a legislature. So, whether it is there or here, will be equally applicable. Finance, the entire Service Act was being operating under the Finance Act itself. Finance Acts, in fact. Okay. So, it is not necessary that it should be only part of the CGST Act only. Something which is there, passed by a legislature, that also would work on that.
Even a 24% interest reduced to 18% to ಹಾಗೆ ಆಯ್ತಲ್ವಾ ಸರ್? ಫೈನಾನ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಮಾತ್ರ ಇದೆ ಅದು.
Yeah, that is a relaxation, specific relaxation.
ಹೌದು. ಫಾರ್ ITC ರಿವರ್ಸಲ್ ನಾನು 24 ಇಂದ 18 ಮಾಡಿದ್ರಲ್ಲ, ಲೈಕ್ that also they've implemented. So department will, in case of cases coming up later on, department will do a direct reference to the Finance Act and deny the refunds, alva sir?
Yeah, there the main challenge is whether pre-deposits for filing appeal, whether amount recovered, amount collected forcefully or deposited under protest or during investigation, inquiry, whether those are all are still hit by this 146 or not is a matter of debate.
So, but illi they've said tax paid or ITC reversed anta idalva sir? Once it is a pre-deposit, it is not a tax paid, no sir?
True. I mean, obviously, but that is what our as a consultant's view. But department would say that you are paid under the head tax code.
Oh, okay.
CGST code, SGST code, only your deposit.
Correct.
So it is nothing but a tax. That is what they will claim. So courts have to come out and give a relaxation, or the board or the council themselves have to give a clarity on this thing. Because see a situation where you got an order today. The act is not today. I mean, 3 months back. If you don't file appeal, you will not get the benefit of 16.5.
Correct.
So you have to claim the benefit of 16.5 or 16.6 only through a statutory order. In the sense, through a process of law. It cannot be without process of law. So when you have to do with the process of law means, then the case has to be alive. To be alive, you have to file a appeal. So to file appeal, you have to make a pre-deposit. So that is what it is. And many
becomes a vicious cycle.
Yeah. And many cases, there may be a situation where the people who have not filed an appeal, probably the remedy available for them is to knock the doors of the High Court under special jurisdiction and say that the benefit of this also should have been extended to us, not been extended. Principle of inequality principle you can try to adopt and try to push for it, set aside the order and demand, or find some lacuna in the order go to a high court and get it quashed and set aside and remand the matter for fresh adjudication, in which you can plead the provision of 16(5). So these are the various ways somebody has to work around.
Got it, sir. Yeah. So shall I move further? The next one. Yeah. I mean, these are all the reference amendments of 74A. With respect to composition provision, where 10 levy under 10 is demanded. So those things, and recovery of excess ISD credits distributed, and in case of 35(6), where officer visits and there is a failure to identifies failure to account goods or services, and there is a deeming supply with respect to such excess goods found, and again in the payment provision, the order for discharge of tax, earlier it was 73-74, now they've included 74A also. And the first proviso to section 50 subsection 1, interest on gross amount, and this gross amount would even apply if it is filed after initiation of proceedings under 73-74 or even 74A. Then similar provision in 51. So determination of amount in default to be made in a manner specified under section 73-74 or 74A. And we have this scrutiny related provision, and 62 non-filers, 63 unregistered filers, unregistered persons where proceedings are initiated, summary assessment, audit, special audit, all this corresponding 74A has been inserted. In section 75 alone, there are some 6 provisions, 6 subsections wherein this corresponding 74A amendment has been put up. Anyways, I'll be sharing this material, so we can definitely go through these things. And 104, where fraudulently advanced rulings have been obtained. There again, 74A7, A2 and A7. So the period to be excluded. So that is, even this provision has been included. And 107(6)B, maximum pre-deposit reduced from 25 crores to 20 crores. And the show cause notice issued by the first appellate authority, the time limits even of 74A has been included here. Then 127, where the residuary provision for passing order for levy of penalty, 74A also has been excluded. Similar amendments we have in IGST law. There are 4 amendments. So one with respect to the ENA or the rectified spirit. The second with respect to this ratification of collective misinterpretation, similar to 11A. We also have a UTGST and a cess amendment corresponding. I've just put up here. And then 16.4 is amended and 16.5 is inserted, basically to connect to 54 subsection 15 for refund restriction to both with payment and without payment methods for the goods subject to export duty. Then the 5th proviso, maximum pre-deposit. Earlier it was 50 crores for first appellate authority and 100 crores for tribunal. Now it is reduced to 40 crores. Similarly, in alignment to 20 crores for CGST and obviously corresponding SGST. I think these were the amendments which were left over from the previous session, and I think majority was discussed in the previous session itself. Anything else to discuss, Venu sir? Or
nothing from my side.
yeah, so it's
any questions from anyone? Okay, I think after 10 everyone are like checked out.
yeah, we have only 50% attendance as well.
Yeah.
Sure.
Thank you, Annapurna.
Thank
Thank you, Ganesh.
Thank you.
Thank you, madam. Thank you, Venu sir. Thank you all. Bye.